morning. Welcome to Law Power Hour. Good morning, Sam Bagensloves, and good morning, Megan Kavanaugh. How are you?
Good. Good morning. Thank you for having us.
Sam, good to see you. Megan, good to see you. I know you're both running for the Supreme Court, and, you know, we've been talking for the last couple of weeks about why you have to vote the entire ballot when you go out and vote. And I want both of you to explain, please explain to our listeners why we have to vote the entire ballot. What's important about in voting that requires you to vote the entire ballot? Megan.
Well, our race and all judicial races are on the nonpartisan section of the ballot, and that is usually between the partisan section and the ballot initiatives. And it's important to vote for your judges, in particularly the Supreme Court, because every decision that, every issue that affects our daily lives is going to be decided by the Michigan Supreme Court. Your rights as parents, your rights as workers, your rights as property owners, contract rights, criminal cases, family law cases, they all will eventually get decided by the Michigan Supreme Court. And so it really should matter to everyone who sits on the court.
Now, Sam, you are an academic individual. You have quite an, I know you've argued a lot of appellate cases, and I know you're a teacher, professor.
Yes.
At University of Michigan Law School. So, from your perspective, why do you think it's important for people to vote?
I think it's important for people to vote, number one, because, the right to vote is something people worked for, fought for, a lot of people died for. It's really crucial that people vote. And if you don't vote, what you're essentially doing is you're saying that the people who do vote are going to decide what's going to happen to you. And on the Michigan Supreme Court, the decisions that the court makes, as Megan suggested, are incredibly important. If you think about, the folks in Highland Park where we're sitting now, who sued the state of Michigan over their education conditions, and the Michigan Supreme Court refused to hear that case, right? That's a concrete effect of the Michigan Supreme Court, and people don't pay attention to the court. If people, when they turn out to vote, would vote all the way down the ballot to the Supreme Court, then they could have some say in who's going to decide these important issues.
Well, now that's an interesting point that you brought up. I cannot ask for your opinion about a particular case, but I'm going to invite our listeners to call in if they have a question about a particular issue, not in terms of an opinion on an issue, but just get an idea of how you think about issues, because it's important. You both come with varied backgrounds. Megan, in terms of your background, you've been a practitioner for 15 years. You've argued many cases before the Supreme Court. Your pedigree, and I'll say this with all due respect, your lineage, historically your family's been involved in the courts as long as I can remember, and you come to the court with a great background. Now, as an appellate lawyer, why do you feel that you are in a position to offer services to the citizens of the state of Michigan sitting on the bench?
Well, I have, as you say, I have spent my career, I've been an attorney for 18 years, or just about 18, and 16 of those years I've been practicing as an appellate attorney, practicing primarily in the Court of Appeals and the Supreme Court, but also the trial courts in both the state and federal court system. I think that actually that's a quality and experience that both Sam and I would bring to the court, is the experience of having actually represented people in the court, and knowing, which I think is important, because it's important to know how the decisions that the Supreme Court is making actually impact real people, to have that real life experience, so to speak, and not just for the particular cases they decide, but they also may have the Supreme Court has a large role to play in the administration of the lower courts. How those courts function, how they work, changes to court rules, administrative orders, access to courts, all those sort of administrative functions, and having justices who are making those decisions, who know what it's like to be in those courts, I think is a great quality and experience that both Sam and I would bring, because, we, sometimes there can be a difference between, how things look on paper and how things work in the real world.
Sam, how do you feel about policing other lawyers? Now, it's the responsibility of the Michigan Supreme Court to oversee attorneys in the practice and to act as the court of last resort. Now, Megan, you've sat on the grievance administration panel and the board for a long time now, haven't you?
I currently sit on the Attorney Grievance Commission, for the last 2 years.
And sitting on the commission, the court of last resort for an attorney is the Michigan Supreme Court. Is that correct, Sam?
Mhm.
And at the Supreme Court, you can make decisions as to whether Barry Keller should practice or I shouldn't practice, couldn't you? Or who should be sanctioned because they're foul-mouthed in the courtroom.
Yeah.
Or who should be sanctioned because they're disrespectful to another jurist or another attorney or to a litigant.
Yeah.
How do you feel about doing that?
Well, look, I think it's really important that lawyers are there they have an awful lot of power that's granted by the public. There is a monopoly on the practice of law that the state creates, and I think that goes with a certain set of responsibilities that lawyers have to their clients to make sure that they're zealously advocating for their clients consistent with the law, but also to other actors in the legal system.
Okay, you talk about a monopoly. If I'm a citizen, I can represent myself at the Supreme Court, can't I?
You can represent yourself, but if you wanted to represent someone else, you would have to be a lawyer.
If I'm a corporation and I'm the owner of the corporation, I can't represent myself, can I?
Because the owner of the corporation is treated as a different person. That's right.
Okay, so in that situation, I would need someone to represent me, wouldn't I?
You would, and I think most individuals find great difficulty in navigating the legal system by themselves and need some help with it. And so we have a system of attorneys who are licensed by the state, who are given special powers by the state, and have to adhere to certain responsibilities. I think that's extremely important. I also think we have a problem in our judicial system of bias of all sorts of kinds. And I think it's important for judges, when they're making sure that lawyers are acting correctly and that the actors in front of the system are acting correctly, that they're watching out for those sorts of biases, whether they're racial biases, gender biases, and trying to act to counteract them.
Well, there's also bias based upon where you come from when you're going to the court.
Absolutely.
Whether you're a litigant on behalf of claimants, or defending, or you're a corporate lawyer, or you're a tax lawyer, you bring all of that knowledge with you, don't you, Megan?
Absolutely, absolutely. And I will say about talking about ensuring that attorneys are. That is the function of the Attorney Grievance Commission, right? Is to make sure that attorneys, because as you say, the public places a lot of trust and responsibility in the attorneys who are representing them in court, and we want to make sure that those attorneys are acting ethically and competently, because that is a tremendous trust, and that's while at the same time, as you point out, the attorney has a right to practice, or you want to weigh those two interests and make sure that they are able to do their job, but at the same time that they are held accountable and responsible for doing it ethically and competently. I think it's a very important factor. And while the Attorney Grievance Commission and then the Attorney Discipline Board looks at that and makes some of those decisions, ultimately, the Supreme Court could be asked to rule on those cases.
So it's reasonable for the listeners to know, when you're voting for a candidate for the Michigan Supreme Court, you're voting for a person who's going to be sitting in judgment of other attorneys.
That is fair.
Is that fair?
Absolutely. Other attorneys, judges that, we review the Judicial Tenure Commission. There's a similar branch that reviews the actions of judges. And, we sit in judgment as judges of people.
So for filing complaints against attorneys or judges, ultimately, that issue could end up at the Supreme Court.
It could.
And the judge could be fined. I'm not going to go into particular judges who've been fined in the last couple of years, because he certainly had enough public notoriety. Or attorneys who are continually getting sanctioned by the court. But those issues come up and they come before the court.
Right.
Now, we've got an interesting mix here. I labeled you a litigant because you're in a firm that is well-known for litigation, and you do appellate work. So most of your practice has been on that side, correct?
Correct.
Okay, and Sam, yours is a mixture. You handle appellate cases,
I do.
and I see that you clerked for Justice Ginsburg, so you've been a clerk,
I have.
and we've certainly seen enough written about Ruth Bader Ginsburg recently.
Absolutely. Absolutely. We're all really moved by her example these days of standing up for what she believes in.
Absolutely. So I call you the academic candidate because of your background. Is that reasonable?
Well, you can call me what you like. I certainly have taught at the University of Michigan Law School for about 10 years. I'm very proud to have done that. I also have argued 4 cases in the U.S. Supreme Court and appeals around the country, supervised all appellate litigation at the Department of Justice Civil Rights Division during the Obama administration. So I've spent a lot of time doing academic work. I've written a couple of books. But I've also been involved in the practice of law, particularly at the kind of practice of law that you do on the Michigan Supreme Court.
Well, I'm saying this respectfully because it's really an important question. Do the two of you believe it's necessary to have a balance on the court of individuals who come from varied backgrounds? I mean, if we had a bunch of trial lawyers up there in the court, we'd still be fighting over the same issues we're fighting over in the lower courts, right?
I agree. I think more perspectives make better decisions. I think it's important to have a wide variety of backgrounds.
Okay, in terms of perspectives, we have 2 individuals, and with all due respect to the justices out there who are running as incumbents, I want to get one thing clear. They were appointed, they never ran for office. Is that correct?
That's correct.
And this is the first
For this
opportunity.
office.
This is the first opportunity for the voters to make an intelligent decision as to who they want on the court.
Absolutely.
Correct.
If you look at the constituency of the court right now, you'll see how many of those were appointed by the governor.
So 5 of the 7 were appointed by the governor. 4 were appointed by Governor Snyder. 1 was appointed by Governor Engler. And there were 2 who were initially elected, who were Bridget McCormick and Richard Bernstein.
So there you go. 5 of the 7 have been appointed. So certainly we know from a philosophical point of view where those 5 votes generally land. And that's a problem because it's not even-handed treatment for the rest of us. And it's supposed to be even-handed treatment at the court. And that's a big issue. How can we resolve this issue if you're elected?
Well, I think it's incumbent on whether you're elected or appointed for the justice to be an independent thinker, to say, that whether you're voting for me or supporting me in an election or whether you're appointing me, that my decision on a particular case is going to be based on the facts and the law, not based on whatever special interest wants me to decide a particular way. I think it's incumbent on the justice to stand up and say, I'm going to decide cases the way that I think they should be decided, not the way that somebody else thinks should be decided.
When we see the United States Supreme Court and people get appointed to the court, they say, well, this is an Obama appointee, this is a Bush appointee, this is a Trump appointee now. And people, predictably will say, well, this is the way the decision's going to go, which is not true. Because once you get on the court, all of those appointments should eviscerate in terms of where and how you got appointed and you should be there to represent the citizenry, whether it's the citizens of the United States or the citizens of the state of Michigan. How do you feel about that?
I think that should be true. I think what we've seen over the past 40 years is an effort, particularly on the political right, to avoid having that kind of situation arise. And so an effort to make sure that the votes of judges who are appointed, particularly by Republicans, are predictable. So it was certainly true in the past that when George H.W. Bush appointed David Souter to the U.S. Supreme Court, he ended up being a quite liberal justice, even though he was appointed by a conservative Republican president. And then the mantra then became on the right wing, no more suitors, that they didn't want to have people who would be unpredictable. So I think what you're describing is an ideal, and I think it's absolutely the right ideal. It's unfortunately not the way that this country has gone, and I think that's a problem. I think what you need to have is judges who are willing to stand up for what's right. You need to have judges who are willing to take on the important issues and aren't worried about upsetting, who their patrons might be or might have been. I mean, I think one of the things, one of the reasons why I wanted to run for this position is because the Michigan Supreme Court is poised to decide so many important issues over the next few years, and we need to have people who are willing to stand up for what's right and not just be following a political playbook.
Let's talk about some of those issues. I'm not asking for your opinion on those issues, but I want the listeners to understand what those issues are. Let's go through a few of those. What's coming up before the court over the next few years? I mean, we can talk about the water issue, for example.
I think that's huge.
It's huge. We can talk about governmental immunity issues are going to be coming up before the court. And none of our listeners understand about governmental immunity and how it works. We can talk about notice issues and whether it's fair that there should be such a short period of notice for individuals to give notice to municipalities, for example, and filing lawsuits. If you file a lawsuit against the city of Detroit, you got 45 days to give notice. Should that be extended? Is there a public policy that we have to deal with? All of these issues are going to come up before the courts over the next years. Can an insurance company deny an individual coverage because they buy insurance and they legitimately pay for the insurance, but they don't live at the address that's on the insurance contract? And they're being denied coverage over that. These are the kind of issues that you're going to have to decide. And these are really important to the citizens because you can't tell the insurance commissioner to reduce rates on insurance, can you?
No, I think also I would point out that, we have 3 ballot initiatives that are going to be voted on in November. And if any or all of them pass, they're likely to be challenged or the application, how they get enacted or enforced are likely to be issues that come up before the Supreme Court too. And it's not just in some of the cases you mentioned are in the civil context, but there will be some important criminal justice issues that come up, the environmental cases that we talk about, the water in particular, family law cases, termination of parental rights, all of those cases, tax issues, like you say, the wide variety, the whole gamut of cases will be decided by the court.
Termination of parental rights is a big issue today, and it's a very difficult issue to deal with because if, for example, shaken baby syndrome, parent commits a crime, they lose their privileges automatically to see that child if they go to prison over that issue. We have a caller. Good morning. Good morning.
In 2014, the case Schuette versus Coalition defending affirmative action, the Supreme Court ruled 6-2 that the Michigan's constitutional amendment banning affirmative action was constitutional. How do you feel about that?
Yeah, I mean, so I know that case very well because I teach at the University of Michigan Law School, which was the target of Proposal 2, because the University of Michigan Law School had adopted an affirmative action program that had been upheld by the U.S. Supreme Court, and it was only after that that Proposal 2 came along to try to get rid of that program. So I've spent a lot of time on that. Obviously, you know, that decision is the law of the land. If Megan or I are elected, we will have to follow it. I will say 20 years ago, I was involved in litigation challenging Proposition 209 in California on constitutional grounds, essentially the same argument the Supreme Court rejected in the Schuette versus Coalition case. And I would urge you to take a look at what we had said. I was working in the Clinton administration, and we thought that actually the political process should be allowed to be followed, and that taking away the option of providing some diversity in admissions was a problem and unconstitutional. Obviously, the Supreme Court rejected that argument, but that's the position that we had taken.
Well, one of the things that's disturbing me, and you brought up earlier, is this education issue. And I'm a proponent of rightful place. And I have a very strong feeling about the right to sue educational institutions for providing inferior education. And the Highland Park case was lost. And as far as I'm concerned, it shouldn't have been lost, but it was lost on technical grounds. So you may have to deal with that issue again with the Detroit Board of Education. The federal courts are dealing with it right now, as you're well aware of. And you would agree with me, and I'm sure you're going to agree with me on this point, that there would be a lower crime rate if we had a better education system.
I think there are a lot of factors that can go into, you know, the I think collective objective that everybody has is to reduce crime rates, right, and reduce juveniles being in the system, in the criminal system, because nothing good happens once they get in, particularly as juveniles, right? So I think there are a lot of considerations that need to be taken into account. But I think things like better education, community involvement, community detention as opposed to imprisoning juveniles. There have been a lot of studies, a lot of programs that actually show that some of those programs help to reduce the rate of recidivism, reduce the number of juveniles that are in the system through educational programs, through problem-solving courts, treatment courts, different diversionary programs, and I think education provides a big part of that.
I just want to give you a big hug for that because it's dear to my heart, and I want to ask you some questions about it. It's really an important issue that we're dealing with. Let's assume that both of you are on the court. You're going to be in a position on that court where you're going to be able to help in the administrative process to establish new rules for the inferior courts in dealing with diversion programs. Is that correct?
Yeah, I think the Supreme Court has an important role to play in that, I think seeking funding to help support those programs, to setting the standards for excellence and for the lower courts. I don't like to refer to them as inferior courts because they're not inferior, they're just on a different level. I think that they do an incredible amount of work, and that's where most people are going to interact.
Well,
with the
I didn't mean to
No, I know.
use that in a derogatory
know.
sense, but
I know.
but in the criminal court, they've got to deal with some horrible problems over there. And at the Supreme Court, you can set guidelines to help the criminal courts develop diversion programs.
I think that's in some ways the most important role of the Michigan Supreme Court, because the court only hears a very small number of cases per year, but the administrative responsibilities of the Michigan Supreme Court sitting at the top of the judicial system are really important, and the role is a bully pulpit. I think, you know, we've done pretty well in this state as compared to other states in terms of expanding so-called problem-solving courts, which is when people get into the criminal justice system, but the criminal justice system isn't a good fit for, you know, these are people who got into the criminal justice system because of problems of a failure to provide education or provide social services or whatever. How can we make sure that the criminal consequences get lessened? I think one thing we could do better, I mean, we do need to expand those programs, but one thing we could do better is actually get get at people before they're in the criminal justice system. So that when I mean, so I worked on some of these issues at the Department of Justice in the Obama administration. When a person has a serious mental illness, instead of the police being the place that they're called, and people ending up going to jail, you have robust community-based mental health services. So those are the people to call, and then people get the treatment they need and don't end up even in a mental health court because they're not in the criminal justice system in the first place.
Well, I had the opportunity a couple of weeks ago for one of my old clients to go over to a district court on a drunk driving charge. And I sat through sobriety court, and it was really a great experience for me to listen to all of the individuals go before the district court judge. And if you've never done it, you should try it. Just find out when the sobriety court is and go in and listen. And everyone talks about what they're doing to stay on the right track with their PBTs, with their testing, classes, programs. They had so many different things going on. I say they had so many different things going on at the court there. They even had their Alcoholic Anonymous classes at the court. The court gave them a room to use on the sobriety court day for everybody to sit down and have their AA meetings, which is really, really important. And this is the kind of program I'm talking about in terms of diversion to help people get back on their feet. We're going to take a break for a minute, and then I'm going to talk to you more about the diversion issue in an administrative point of view, because I want your opinions.
Excellent.
Wonderful.
And this is not asking for a legal opinion
Sure.
in terms of a decision on a case. I want to be very clear. And listeners, I know you're waking up out there because it's so cold out there this morning. I haven't heard from you, but the weather's changing. We want you to call in. We'll be back in a couple minutes.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
Now, I know I brought up this issue, and it's something that may have not covered in your campaigns, but I think it's important for the listeners to understand that if you're on the Supreme Court, you have administrative functions at that court, correct?
Correct.
Yes.
And in terms of making policy decisions that affect the citizenry of the state of Michigan, that's what the Supreme Court does, correct? In part.
In part, in the administrative, sure.
Right, and the administrative side. I have to be very careful how I say that,
Right.
because you're not legislating at the
Correct.
court, you're not passing laws at the court, but you deal with court rules, for example. You deal with standard jury instructions. You deal with scoring individuals who commit crimes. You have to look at how they score to see if the scores are correct and they're done correctly, and sentencing guidelines.
Sentencing guidelines, sure.
Right, so you're involved in that, and I call that part of policy and administrative functions that the court performs. Is that correct?
I would agree. Yeah.
Okay. Tell me if I'm wrong.
No, I think you're correct. They play the court plays a big role of, like you said, what are the right civil jury instructions? What are the right criminal jury instructions? I think the court collectively, and then as individual justices, you have involvement in different administrative roles in working with lower courts and working with the court administrator's office, in making sure the administration of the courts is working properly in the way that it should, most efficiently, most fairly, most effectively.
Now, in terms of sentencing guidelines, for example, does the Supreme Court have a role in terms of sentencing guidelines?
I have not practiced in criminal law. I know that they review cases, that would come up in the context of cases that are brought to them of whether a particular, decision in a particular case is in compliance or outside of guidelines, and where and under what circumstances that can be done outside of guidelines.
Well, they have to interpret the sentencing
Sure.
guidelines. Those issues come before the United States Supreme Court when they become the law of the land. The Michigan Supreme Court has to follow the same rules. It's the Constitution. You are required to follow the Constitution of the United States when you sit on the Michigan Supreme Court,
Of
correct?
course, yeah.
Right.
And if the United States Constitution gives you the right to remain silent, that means in the state of Michigan, you have the right to remain silent, correct?
Correct.
Okay, I just use that as a simple tool to open the door here. So if the United States Constitution states that there are sentence guidelines that have to be followed for minimum and maximum, and you can't deviate from those guidelines. We can't have jurists in the lower courts, because of some prejudice over a particular issue, sentencing a person for assault and battery to 20 years in prison, if that goes far and beyond the guidelines. You know where I'm going?
Absolutely.
So you monitor those things, don't you?
Right.
Okay. So if there's a deviation, and this is what I said I wanted to talk about a little bit, a deviation in practices where the court is now given an opportunity to come up with another alternative for individuals, instead of going to prison, to get rehabilitated first to see if they can get rehabilitated. Do you think that's a good idea?
I would say in many cases it absolutely is a good idea. I mean, we have too many people in the criminal justice system in this country. I think, most people who are involved in the criminal justice system would tell you that, and certainly most people in the communities affected by folks who are caught up in the criminal justice system would tell you that. And unfortunately, because of the way that our society has cut back on education and social services and government, honestly, at various levels, a lot of social problems have ended up in the criminal justice system. And what problem-solving courts and diversion programs and all those things are about is folks in the judicial system and in the criminal justice system saying this is not a criminal justice problem. Someone might have committed a crime that that fits the definition of a crime, but we're not going to solve the problem just by locking this person up for a long time, separating them from their communities and depriving them of opportunities actually to be productive in society. What we need to do is figure out how to deal with this problem appropriately, so that we have less crime and less social costs in the future. And I think at the point of the role of the Michigan Supreme Court in all of that, is a couple of things. I mean, as you say, it's to review the decisions of the other state courts that are deciding whether someone goes in or out of a program. But also, this administrative responsibility is huge, to issue rules for the lower courts. And I think there's another piece that I think you haven't talked much about, but is really important, which is the bully pulpit rule. So the justices of the Supreme Court, I mean, there are only 7 of them. They're all elected statewide. They play a very powerful role in talking to the legislature, in mobilizing support among the people and the executive branch about for funding these kinds of services that keep people out of criminal justice when they shouldn't be in criminal justice. And that is something we've seen some justices do well. I think, Justice McCormick does a great job of going to the legislature and pushing for a partnership on these programs. But I think we could use much more of that. And that is something that, again, the court decides a few cases a year. I mean, it's a few dozen cases, honestly. What matters much more in some ways is this administrative responsibility.
Well, that raises another issue. Can we expedite the process at the court? I just had a remand on a case from the court, and it's a 2013 case. It's coming back for trial, and now it's under review again, and it may go up to the court again. I could be 7 or 8 years away in total from the day I started the lawsuit in 2013. I'll be at 2020 before I get to the courtroom to try the case. What can we do, or what can you do on the court, either to handle more cases, to facilitate the movement of the docket so that we get these cases decided? You're an appellate lawyer.
I am, and this may be an unpopular opinion, but I don't.
There's nothing unpopular.
I caution against. I don't think expediency or taking more cases or speeding up the appellate process is necessarily the best way for the appellate courts to work. And I say this based on my experience. I mean, I think that over the years, and this is largely a factor, I think, of caseload at times, that the waiting period or the time from filing to disposition, either in the Court of Appeals or in the Supreme Court, has gotten less over the years. But I think there are a couple. I think there's danger in sort of speeding it up or streamlining it. I know that there was a program that I was involved in a number of years ago. I can't even remember how many it was at this point, where the Court of Appeals implemented a sort of a rocket docket for summary disposition cases, with the goal to speed up the time for resolution of cases that were decided on summary disposition, right? That were decided without going to a jury. And they thought, well, that is just sort of a broad category of cases, that could be cases that could be streamlined. Except, as it turned out, I think, and somebody did a study, something like 80% of the cases that actually get decided by the Supreme Court, which are the cases of the most sort of jurisprudential significance, were summary disposition cases. That sort of broad category of shortening the time period where people had to respond, shortening the number of pages in which they could get their opinions expressed. I don't think that is a good way to handle those cases. So I think right now, as we know, if it's argued in the Supreme Court, if a case is argued in the term beginning in October, that it has to be decided by the end of July. In a very few cases, it could get bumped over to the other case, but they have, less than a year of cases getting argued from argument to decision. Obviously, there's some time period for filing and for briefing before that, but I think it's very important, particularly when the court is deciding issues of such importance and that are going to have such a significant impact on people in Michigan, on the practice of law, on the rights of everyone, that you want a decision that is going to, you want the time to be taken that's necessary to get to the right decision. And I think that's just my opinion as an appellate process person, I think.
Well, as a litigator, from my perspective, I feel very strongly that it's a long wait. And as a litigator, I can honestly say this, and I mean this from my heart. It's gut-wrenching when we get decisions back, and it's 5 or 6 years, and all that time and effort has been put into a case, and you stare your client in the eye and say, well, you lost because of an interpretation of what constitutes arising out of, for example, or what constitutes an activity. For example, if you sue a municipality over a bus. And the issue is, was the bus a bus at the time of the accident, or was it being used for a different purpose? And those are issues that end up at the Supreme Court.
Sure.
I don't have much hair left in my head, but I pull it out when I deal with that issue. If the bus is parked and it's out of service, it's not a bus. I'm not going to ask you to explain why it's not a bus, but I had mentioned earlier in the day, we run into the same problem as to whether we have recreational land use of a particular piece of property. I mean, how far does it extend in terms of recreational land use? When I was a young lawyer, if you went to a concert and you snuck into the concert and you were injured, you were a trespasser, for example. And then I learned if you were on a snowmobile and you didn't have a permit to go into the park, you were a trespasser. And now it's gone the pendulum just swings all the way to one side, and then it swings back to the other side. What I would like to see is some even-handed treatment on the court. Now, do you think we can get to the point where we get even-handed treatment when the two of you get on the court? Because I want you on the court.
I think that's what we're hoping, and I think what Sam and I would bring when we're elected. I think another thing, like you're saying, about the pendulum swinging, that's a problem. I don't think, the public has a right to depend on the predictability and the stability of the law. And if the law is changing based on, elections every 2 years, then there's something very broken in the justice system.
Okay, now you're elected for 8 years.
Correct.
But God forbid, if somebody dies or becomes infirmed, there's an appointment, and that can change the balance in the court right away. And that's what we want to avoid, isn't it?
Yeah, we don't want the decisions of the court to change based upon the composition of of who the justices are that are sitting on the case. I mean, obviously, we're all human beings, and as we've talked about, we all have differing backgrounds and differing perspectives, and so you're going to get, obviously, individual input contributes to the decisions of the court. But I think it's very, very important, and that justices need to be stewards of the law, and that the public should be able to rely on the consistency and the stability and predictability of the law. I mean, when you're trying to figure out how you're going to structure, your will, or how you're going to provide for your children in the event of your death or that, like, you should be able to consistently rely on, I know that this is the law and it's not going to change depending upon, whoever gets elected in the next cycle.
But it does change. It's like a pop-up when it comes to governmental immunity as to who you can sue and who you can't sue and why you can sue them, who's protected. I'm very serious about this.
I mean, I think that it's important that we have consistency in the law, right? So we need to have a legal system people can rely on. It's also true that the kinds of issues you're talking about, I mean, there are very fundamental values at stake, right? And so for someone, and there are fundamental values at stake, and the law is often ambiguous, right? So it's not the case that we could all look up the law in a book and we'd find a single answer, right? So it really matters who are the judges, and if you have judges who have spent time actually representing individuals and who focus on issues of redress for violations of constitutional rights, you might get one answer to whether a government agency that violates your rights can be sued. If you have folks who have spent a career more aligned with, being prosecutors or representing big corporations, they're more likely to focus on the other side of that balance. I mean, that's just humanity, and it's one of the facts here. I do think it's important. We had in this state, particularly when Governor Engler made a whole series of appointments early in his administration, this sort of wrecking crew with old precedents, where they had a bunch of old precedents that they thought were wrong, and they just knocked them all down. And
Summarily knocked them down.
Yes, and often right away, and that's I think that's something to be avoided. This is not the kind of election where what you're doing is electing people who are going to just make policy on their own.
Right.
We're trying to, in the courts, trying to make sure that you're implementing the policy that, other branches of government have adopted. But it's also important to understand it really matters who's doing that, because there are questions of value. There are often important principles that are in conflict, and you need to have people who understand what's at stake and who have a perspective on what's at stake that matters.
Okay, now, we're going to wrap up here because it's getting to the top of the hour. What's really important is that you're both running nonpartisan. Everybody's running nonpartisan, correct?
Correct.
And the two individuals on the court who have the designation of incumbent only have that because they were appointed. They never ran or never stood for election, correct?
That is correct. This is their first election for the Supreme Court.
And it's your first election for the Supreme Court, and we need change on the court. We need to get a balance on the court, so we need to get you elected. So what do you want our listeners to do?
Well, we want you to vote. Obviously, it's very, very important, as we've been talking about, and that's why we're here, and that's why it is such a fundamental right to use your voice through the power of vote. We want you to stay on the ballot, to vote all the way, vote every race. We don't have straight party ticket anymore. Not that the nonpartisan judges were included on that, but that means that voting is going to take a longer. There are going to be longer lines likely. It's going to take a longer period of time to vote the whole ballot, because it's a big ballot, right? We have ballot initiatives and a number of partisan races, a number of nonpartisan races. So we really urge you to stay on the ballot. Vote absentee, I think, is helpful, because you can then take your time to make sure that you voted every race, because every race really does matter. And then go out and make sure that everyone in your circles, in your communities, in your schools, in your workplace, at the grocery store, wherever it may be, and spread that message as well of how important the Supreme Court is, as we've been talking about, as Sam just articulated, how important it is who is sitting on that court and making those decisions, and encouraging everyone else to vote for me and Sam.
And I think the one thing, because it's the nonpartisan ballot, there are no D's or R's next to our names. You have to know the names, and we haven't said our names that much. So I'm just going to now say our names a couple of times. So I'm Sam Bagenstos. This is Megan Kavanaugh. This is Megan Kavanaugh. I'm Sam Bagenstos. You have to remember the names Sam Bagenstos and Megan Kavanaugh, because you'll just see a long list of names. There are 6 names on the ballot. It's Sam Bagenstos and Megan Kavanaugh, who we hope you will vote for.
And they're near the top of the ballot because it's in alphabetical order.
It's different in each district.
Depends on where you are.
Depends
Yeah.
upon where you are. The
Okay.
clerk has some authority to
Well, that's very
alter
interesting.
that.
We'll get into that on another day. But what's important is that you vote for them. You get out and vote, because I want you to understand, from a perspective of a practicing lawyer for 50 years, that whoever sits on the Supreme Court rules over the state of Michigan. I don't care who the governor is. I don't care who your legislature members are. I don't care who the tax assessor is, the dog catcher. The Supreme Court rules in this state, and if you don't vote on the Supreme Court, you're hurting us, all of us, collectively. Thanks for listening. Have a great week, and put on a warm coat, because it's going to be in the 40s today.